All right, perfect. Welcome, members. This is the regular scheduled meeting of the Collection Service Board. We'll call this meeting to order. It is now 9:34. Let's go ahead and do the roll call. Josh Holden, Greg Swirsky,
Here.
Chip Hellman,
Here.
and Jason Hill.
Here.
All right, great. Thank you. We do have a quorum. We can move on then to the notice of meeting. Let me read that into the record. Notice of the November 18th, 2020 meeting of the Collection Service Board, including date, time, and location, has been noticed on the website since August 15th, 2019. Additionally, this month's agenda has been posted on the website since November 9th, 2020. If we can, we'll need to move to the statement of necessity. Please keep in mind, since this is an electronic meeting, that every actionable item will result in a roll call vote. And we'll also have to vote on the statement of necessity. Hugh, would you mind reading that into the record?
Sure thing, I'd be glad to do that. Statement of necessity, according to TCA section 844-108B2, if a physical quorum is not present at the location of a meeting of a governing body, the governing body must file such determination of necessity, including the resuscitation of the facts and circumstances on which it was based, with the Office of Secretary of State no later than 2 working days after the meeting. Furthermore, TCA section 844-108A3 defines necessity as matters to be considered by the governing body at that meeting require timely action by the body, that physical presence by a quorum of the members is not practical within the period of time requiring action, and that participation by a quorum of the members by electronic or other means of communication is necessary. This is the routinely scheduled meeting for the Tennessee Collection Service Board, and the purpose of today's meeting with the members attending by teleconference is to discuss the agenda as noticed on the website earlier. This concludes the statement of necessity, and I would like a motion to accept that and a roll call vote if possible.
Thank you, Hugh. Do we have a motion to accept the statement of necessity?
Swirsky moves.
I move.
All right, thank you,
I'll
Greg.
second.
All right. Chip, we've got a motion from Greg Swirsky, and we've got a second from Chip Hellman for roll call vote. Greg Swirsky.
Aye.
Chip Hellman.
Aye.
And Jason Hill.
Aye.
Thank you, gentlemen. We'll get that filed over the Secretary of State's office and taken care of. All right, to the agenda then. I trust everyone's had an opportunity to look at all the docs. Do we have a motion to accept the agenda, or is there any revisions that need to be made?
I move we accept. It's Chip.
All right, thank you, Chip. We have a motion from Chip to accept the agenda as written. Do we have a second?
Sure, this is Greg.
All right, thank you. We have a second from Greg Swirsky. For a roll call vote to accept the agenda as written, we have Greg Swirsky.
Aye.
Chip Hellman.
Aye.
Jason Hill.
Aye.
All right, thank you, gentlemen. That's passed then. We'll move on to the August minutes. All right. Do we have a motion to accept the August minutes, or is there any discussion as to edits or revisions?
I didn't see anything to be revised, so I'll move we accept the August minutes.
Okay. Thank you, Chip. We have a motion from Chip Hellman to accept the August minutes. Do we have a second in that regard?
I'll second. Jason Hill.
All right, thank you, sir. I have a second from Jason Hill for a roll call vote then to accept the August minutes and have those published. Greg Swirsky.
Aye.
Chip Hellman.
Aye.
And Jason Hill.
Aye.
All right, thank you, gentlemen. We'll get that on the website and taken care of then. For the director's report, not much to report here except for just a couple little like housekeeping items, and then of course the budget. So let me go ahead and just get into the budget, into the dough there. We covered all of the last fiscal year 2020. So we're looking at fiscal year 2021. We've only got 3 months of record to review since we've covered everything up to that point in our last meeting. There was one item that I'd like to note. If you look on the first column, July 20, legal cost backs, I've highlighted that for you. That's $7,000 there in legal cost backs. That is an error. That's a misallocation. There was a miskey for those legal hours reported. That will be reallocated. You should see that probably in our next budget report, but we'll stay on top of that. I'm just waiting on a revision to be so noted and to be applied to the next budget. So I'll keep tracking that. But other than that, you'll see below at the historical trends below that it pretty much mirrors what we've seen historically. I will just give you sort of a snapshot of where we're at right now in this first quarter. We're looking at about 31,000 total in revenues, closer to about 32,000, and then we're looking at about roughly 26 to 27,000 in expenditures, giving us a net surplus of around $5,000. Is there any questions as regards to the budget itself? We kind of went into more detail, I think, in our last meeting as to what each of the rows mean and what those allocations are. This is for informational purposes. Won't be any vote required on this. This is just something we delivered to you so that we can track all of those expenses and to make sure that we're in good fiscal health. You will see that we have a reserve amount of right at approaching about $890,000. Any questions?
I have a question, this is Chip.
Yes, sir.
In terms of the number of licensees, the number of companies licensed or applying for actual licensees, how is that trending year over year? And I know we're on a 2-year renewal cycle and so forth, but it would be nice. I don't want to put you guys through any too much work, but is that a number that can be easily obtained so we can see how this is trending within the state in terms of companies being licensed?
I can pull a number of total licensees for the next for the record at our next meeting. That won't be a problem. I can tell you that there has been a modest decrease, a sort of a gentle slope downward. I would say that it's probably stabilized as of recently, primarily because of the exemptions. Folks are realizing that they don't need 4 or 5 branches. They can put their locations under one license. So that I think cleared a lot of the licensees. Initially, we saw sort of a stark decline, and then it sort of leveled off to a gentle, and now it's sort of plateaued a little bit. And then also the exemptions. A lot of folks had licenses they really didn't need. And I think when they became aware of those licensing, the exemptions, and that information was trotted out, I think that we've seen, of course, a decline in licensees there as well. But I haven't seen anything to make me think that there's a hemorrhage or that's going to continue. I just think as a result of those two, I think stimulus or items that sort of introduced themselves into the paradigm, that we've seen that decline. And I think it's pretty easily attributed to that. Other than that, though, I haven't seen anything that concerns me or makes me think that this is going to continue in that direction.
Okay, that's great. And then just a follow-up question to that, Glenn, if you don't mind. But if someone wanted to get a list or see who actually is licensed, let's say I, as a consumer, received some sort of notice from a collection company, is there a place on the website where I can actually go and just confirm that they are a licensed agency and are clear to do business in the state?
Yes,
so that
sir.
I can avoid. Okay.
Yeah, there's 2 places for that. There's verify.tn.gov, and it's on the regulatory board's website. If you go up to, I think it's in the contact tab, drop down, it's verify. You can verify a license right there. There's
Okay.
also another place too. If you wanted more of an exhaustive list, you could do a public records request, and that'd be something that we would be happy to fulfill, where we could give you basically a rundown, a mailing list of all the licensed agencies in the state of Tennessee. Now, that's only available to Tennessee citizens per statute, but if you're a resident in Tennessee, then we could provide that as well.
Okay, and so is there a formal way? I guess that makes sense. But a consumer would just go, I'm thinking of a consumer with all
Sure.
the fraudulent companies out there trying to get money, particularly from older citizens, perhaps. Verify.tn.gov is where they can check the legitimacy of the claimant, I guess. Or
Yes, sir. That's correct.
okay. All right, that's great. Thank you very much.
Yes, sir. Thank you for asking. That's that is always a concern. So that's we want to stay on top of that. Thank you for bringing that forward. Okay. That's all I had for the budget. There was just a couple other housekeeping items. one thing I wanted to remind you guys is that our next meeting will be January the 13th. We're sort of we're going to get off cycle a little bit. We'll still do quarterly meetings, but we were used to starting that in February. We're going to do January and then April and then going forward. So we'll be off cycle a little bit, but the days will be the same. It'll be a Wednesday at 9:30. So it'll be pretty easy to track. I just want to keep that if you guys want to mark your calendar for the next one. And of course, you'll get all those documents turned in a year. So that's all we have for the schedule. One other thing too is I sent you guys an email this morning in regards to consumer tips release, a publication. A couple of our folks have been working on just making sure that we provide information or can provide as a service to our consumers and provide some tips for them to consider in the consumer protection sort of vein. But also to as an outreach to let folks know we're here, and some of those things that you like that we would include in that would be directing folks to our resources like verifytn.gov, and we hope to continue to do those type of things. It does look like a local paper did pick up the most recent story that was compiled and put together. So you know, a lot of things happening, a lot of folks at work and doing we're in a variety and myriad of sort of ventures. So there's no rest for the weary. So we're always looking for opportunities to connect with our consumers, but then also with our licensees and staying abreast of whatever sort of improvements the industry recommends or has for us as well. And when we also welcome our expertise panel here, as you guys come up with things that we can carry forward or that we can apply and appropriate, we always look forward to hearing from you as well. Okay, that's
a good piece.
Yeah,
Yeah,
thank
well
you.
done.
Thank you, Bob and Angela. I know you guys are on the line. Appreciate you putting that together and editing that and getting that in the hands of our public information officer as well. All right, I think we're ready for the legal section of our agenda. Q, I believe the legal report was in order.
Absolutely, I can read through read the cases into the record now if you would like.
Yeah, that'd be great.
Okay. 2020-055-461, 2020-056-041, 2020-051611, 2020-053811, 2020-056621, 2020-059471, 2020-057631, 2020-057681, 2020-067391, 2020-067241, 2020-067181, 2020-073391, 2020-075861, 2020-077501, 2020-073921, 2020-076821, 2020-078331, 2020-075841, and then there is one case to be represented, and that is 2020-007701. And if you have any questions, please let me know.
All right, gentlemen, thank you for reading that to the record, Hugh. And then, gentlemen, typically what we do is just start with any cases particularly that you had of interest, and then we'll talk about those, and then we'll just sort of any modifications that we make in the recommendations, we'll note those, and then do a general summary, and then vote it all at once. Is there any questions about particular cases that you noticed that you'd like to discuss?
I have two, if you don't mind. I had a chance to review the report. So number 14, which is 2020-077501.
Okay.
This pertains to the adding of collection fees to a balance, to a principal balance that is owed. And so is it your guys' understanding, based on this, your recommendation to close, that if the creditor adds the collection, if there is an underlying credit agreement which calls for a collection fee to be added if the account is placed with an attorney or a collection agency for collections, that if the creditor, the original creditor, adds that collection fee to the balance and then assigns it to the collection agency as a total amount due, that it's legal and appropriate for the collection agency to try to collect the entire balance, including the fee?
That's a good question. My understanding of this particular complaint, by reviewing the files that were presented here, this was actually an underlying fee that dealt with the initial creditor and the consumer. So I didn't see where the actual fee was added by the collection agency, but there was a particular fee that was part of an underlying contract between the initial creditor and the consumer that went to the total balance that was trying to be collected on. So I'd have to get back to you on the actual, on your scenario, which seems to be a little bit different. In your scenario, you're saying the collection agency added the collection fee and then
No.
it increased the balance. Okay.
No, I'm sorry. I was trying to duplicate exactly what you described here in number 14. So if I misspoke, I'm sorry. But my question, I guess, goes back to, so through the years, unfortunately, I'm the oldest one on this call, and I've been in the collection space since 1983. But through the years, there's kind of been this back and forth about whether a collection fee can be added to a balance by a creditor if there's an underlying credit agreement that calls for it. We know, or at least I suspect, and have always operated under the belief the collection agency cannot add any fees, regardless of the underlying agreement. But if the creditor does that prior to the account being assigned for a collection to a collection agency, is that legal and appropriate? That's really kind of my question. It's I suppose a legal question, but it kind of changes if that is allowed. It kind of sets us up for kind of a game changer here, because why wouldn't, I mean, virtually every reasonable creditor has some sort of underlying agreement where fees are added if there's litigation or collection agency involvement. So I guess I just want to make sure I understand the rules first. And so, Greg, are you with me on this just in terms of that question, or is this a practice?
No, I do understand the question, Chip. My understanding is, and has been, is that if the creditor, the original creditor, has an agreement with the consumer that they will pay certain fees, it has to be, this is my understanding, of course, I'm not an attorney, it has to be spelled out to the T. It can't just say all fees associated or just an arbitrary number. It has to be spelled out, whether it's 20% of the balance, but it has to be very specific in the original creditor's contract. And if it is in the contract and it is spelled out very specifically, then they can add that balance prior to placement with an agency. That's my understanding, and I'm open to any interpretation.
Okay. Is that the board, the staff's understanding as well?
Yes, it is. This is Hugh here. That is my understanding. If you would like, I can certainly research this and get back to you at the next board meeting with something a bit more detailed. But that is my understanding of the difference there.
I would appreciate it if you don't mind. And I don't want you to spend hours and hours. The purpose of this board is to not make assignments to the staff that are, overly burdensome. at the same time, I think it would be great if you could weigh in on that. Maybe not as obviously as legal advice, but based on what you see with a little research, I think that would be helpful. Because as Greg described it, which I don't disagree at all with you, Greg, but I've seen very few agreements to credit. So a bank would have very specific, a bank type relationship, possibly even a credit card type company would have a very specific credit agreement that somebody has signed. Where it gets gray to me is what if a healthcare provider just kind of blankets with a statement in their agreement that you'll pay a reasonable cost for collection if it's I mean, is that enough to trigger that, or does it need to be really spelled out like Greg alluded to?
Yeah, and that's my understanding, Chip, that it does have to be spelled out, but that's just the way, right? You know, we will not add fees for a creditor, even if they, and once again, this is my understanding, even if they put in, you're responsible for an extra 30%. I don't think that flies either. I think it's got to be specific to actual costs incurred and not arbitrary.
Okay.
That's my understanding.
It would be great to know that.
That's been how we've operated in the past. That's been sort of our approach as a staff. And so, you know, you already spoke to that. I do think we could, if you like, Chip, we can represent number 14 with some clarification. Would that be your recommendation?
Well, I don't disagree with I mean, that's fine. Yeah, I guess that is my recommendation. I don't disagree with the decision on number 14. I really was asking more from just an overall. Okay. But if that's a way to get it sort of before us next time,
we can take those separately.
Works.
We can close this one out and then as recommended, and then just bring that forward as a matter of discussion and clarification at the next meeting, and treat those two separate. That would be fine.
Okay, good.
All right. Thank you for addressing that. You had another one, Chip?
Okay. Well, it's the case that is being represented. Case 19, number 19 here, 2020007701. So maybe this is kind of old news, but I just want to double check. So you really have made every effort that you can to locate this company, to issue them, you know, the correspondence, and you just can't find them. So essentially, we're just going to close this file and flag it. So if their name pops up again, or if we receive some other information in the future that would allow us to forward correspondence to them, then we would do that. But for now, it just kind of goes away quietly with that flag. Is that what we're saying here?
Yes, sir.
Yes, sir.
We have to get service, and so service seems to be our biggest problem. Hugh, you could probably expound on that a little bit, but we're hoping that, you know, at some point, if we're fortunate enough to be able to proceed with NMLS, a lot of those problems will take care of themselves because we'll get service once it's entered into that system. So, but right now in our current situation, if we can't get service, then it's really difficult to move forward.
Yeah, I agree with that. It's essentially I believe we talked about this a little bit in the last board meeting as well. It's essentially a due process issue, and you can't move forward with litigation against an entity or an individual without due process. And part of that is putting them on notice that, you know,
right,
what the next steps are going to be. And in this case, you know, 2 consent orders were sent out, and a clear report was also done. And there was really no solid address there. So it's been my understanding that with cases such as this one, the best option is to close it and flag it, since we do have that ability in our system. And if this licensee comes back for renewal, then we can address this at that time. And that's sort of,
Makes sense.
yeah, it's not necessarily a perfect scenario. I do think it's the best scenario.
Yeah, it's really all you can do at this point. I mean, you haven't just waved, not waved as in, I mean, waved like a flag. You didn't just sort of send stuff out, hope it stuck. I mean, you really made a serious effort to try to find this company, and I don't think there's anything else you can do. So I agree with your recommendation. I just wanted to make sure I understood it. Because when we do get on the new system, Glenn, all these companies that are flagged, you're going to be able to go back in.
Yep.
And okay.
Yep. That'll be one of the first things we do.
Yeah, that's great. Okay, awesome. That's all I have on the legal report. I agree. I personally agree with all of your recommendations.
Okay, thank you.
Was there any other questions from the other members as regards to any case specifically?
I'm good.
Okay. I tell you what, Hugh, if you want to you've already read those into record, maybe just as they're enumerated, and then what your recommendation is for the record, and then we'll take one motion at the end of it.
I mean, read the cases individually again.
Yeah. Just number one would be closure, and then number two.
Got it.
Yeah.
Okay. Okay, so case number one, recommendation is closure. Case number two, recommendation is closure. Case number three, recommendation is closure. Case number four, recommendation is closure. Case number five, recommendation is closure. Case number six, recommendation is closure. 7, recommendation is closure. Case number 8, recommendation is closure. 9, recommendation is closure. 10, recommendation is closure. 11, recommendation is closure. Case number 12, recommendation is closure. Case number 13, recommendation is closure. 14, recommendation is closure. 15, recommendation is closure. 16, recommendation is closure. 17, recommendation is closure. 18, recommendation is closure. 19, which is the case to be represented. The recommendation was a consent order with a $250 civil penalty and authorization for formal charges for failure of a licensee to respond to the board's complaint in accordance with TCA 62-20-115-3. The new recommendation is to close and flag as insufficient information to go forward with litigation.
Okay, thank you, Hugh. Do we have a motion from the membership in regards to those recommendations?
I'll move to accept those. Swirsky.
All right. Thank you, Mr. Swirsky. We have a motion from Greg Swirsky. Do we have a second?
A second, Hellman.
All right. Thank you, Chip. All right, we have a motion from Greg Swirsky, a second from Chip Hellman for a roll call vote. Greg Swirsky.
Aye.
Chip Hellman.
Aye.
And Jason Hill.
Aye.
All right, thank you. We're taking care of the legal report. Hugh, did you have any other things that you'd like to add for this portion of the agenda?
I do not have anything else at this time.
All right, thank you.
Mhm.
One quick note as well. One of the benefits of working from home is we have our computers in front of us, so I could do a license count. So Chip, we don't have to wait until the next meeting. I can tell you how many licensees we have, and we also did a public records request recently. Yeah, we have 812 licensees, active licensees right now.
Wow.
Gee whiz.
Mm.
That's a big number bigger than I expected.
We used to have some over 1,000, 10, 1,100, somewhere in that range, and then we, of course, filtered some of those out with them putting those locations under one license, and with the exemptions. So yeah, we're about
Yeah.
right at 8:12.
Yeah, that's great.
All right.
Thank you.
Yes, sir. New business. Does anyone have anything that they'd like to discuss? Okay. I'll note your silence then, and then we'll move to the adjournment. Do we have a motion to adjourn?
So moved.
All right. Thank you, Mr. Hellman. Do we have a second?
Sure, Greg Korsky.
All right. Thank you, Mr. Swirsky. We've got a motion from Chip Hellman to adjourn and a second from Greg Swirsky. For roll call vote, Greg Swirsky.
Aye.
Hellman.
Aye.
Jason Hill.
Aye.
All right. Thank you, gentlemen. We are adjourned. Appreciate your time this morning. Y'all have a good rest of the day.
You too, thanks.
Thank you. Bye-bye.